We agree. I mean, next one.
Recommendation from the Ministry of Justice and Constitutional Affairs. Section 23(1), further consideration to be given to this matter with a view to determining whether the subjective application is in the best interest of the child. It is proposed to review Section 30 and Section 22, subsection 3.
Why subsection 3 of what?
So, Section 22, subsection 3.
Subsection 23, subsection
22.3.
That's 22, 3 it says here.
In light of section 30. So can we
Yes.
come back to it then at section 30? Make a note of it. We'll come back to it.
There is also a recommendation from the police, the Jamaica Constabulary Force, in relation to Section 22, 23, and 25, in reference to the police discretion for warnings, cautions versus charges. We recommend that the Act expressly requires the police to consider factors including the seriousness and nature of the alleged offense, the sufficiency and reliability of the evidence available to support prosecution, and the overarching principle of the best interest of the child. The following recommendations are for Section 23. It is recommended that the term formal warning be expressly defined or qualified to mean court proceedings, proceedings in Section 26. And consideration should therefore be given to amending Section 23 to expressly address the post-formal warning process. The Act should clearly state whether a child who receives a formal warning must be referred to, or whether referral is discretionary, and if so, the criteria by which such discretion is to be exercised. Section 23 should expressly identify the means of referral, require the constable to provide written notification to the Child Diversion Office and the Child Diversion Committee, amending Section 23 to include express guidance on the referral process aligned with the provisions in Section 26, 28, and 30.
Right. Any comments on what I think the Jamaica Constabulary Force is asking, and to a certain extent the Ministry of National Security, is whether guidelines should be given as to when and in what circumstances you issue a formal warning as against a charge. But here again, the Ministry of National Security said leave it to the discretion of the officer, while the Ministry of National Security and the Jamaica Constabulary Force want something more formal. Any comments, colleagues? I think, if you don't mind, we
Mr. Chairman,
yes, yes.
can I ask a question in relation to the comment that the JCF made about the referral to the Child Diversion Office? Can I just ask, given, and this applies to Section 23 as well, informal warnings, where the constable is referring the matter or notifying the Child Diversion Office and the Child Diversion Committee in a circumstance where the child has not been diverted to the program, there's no referral to the program. When they're notifying the office of this child, and in 23, certainly there's a prescription as to what the notice must contain. And in 24, sorry, in 23, I can't recall. There's no prescription as to what a notice is to contain. How does the Child Diversion Office and or committee treat with that notification that they receive? And I'm asking this question in the context that presumably this child does not exist to the child diversion office or the child diversion committee. So a child is formally or informally warned, a notice must go to these offices. What file does it go into? Is a file created for that child? And what should that file created for that child contain? Is it just that they are to receive a notice that John Brown in Community X has been warned, formally or informally? I am still grappling with how this process is supposed to work on the ground.
Any comments, Ms. Clark?
If the child diversion office gets a referral that is an informal, well, it's a notification, but an informal or a formal warning, usually there is no action taken by us. The action that is required is from the police at that point. There is an eligibility scoring sheet that is toward the back of the referral that allows the police to determine whether it is an informal warning, a formal warning, or a caution. For sexual offenses, it is an automatic caution, but for the informal and formal, nothing is done by us, we just document it for the ones that we have received, but for the cautions, that is where intervention is provided by us.
You're calling it a referral. Is that a referral or is that a notification?
According to the legislation, it is a notification. Currently, as we have it, because the information is sent on the same form. So we have a referral book that is done in triplicates. One copy comes to us, and it is done on the same form. So while we're aware that I know the JCF, we might get to that, where the JCF recommended that for informal and formal, we should have a prescribed form for the notification to be sent to us, and then the referral book for the cautions. So currently that doesn't happen, but we receive the information once it comes to us.
What I think, if I might follow up a bit, and I think this is the challenge that I think Senator Golden Campbell has. Both the informal and the formal, yes, you notify the child diversion office, but nothing really happens after that. And you see, my view, yes, if the child is charged or referred, then the child diversion office takes it up. So it does look on the face of it that the informal and the formal warning are basically police, assessment, and they didn't see the need to go further than to informally or formally warn the child, but also to let the child diversion office know about it. Somehow it seems to me that both in the informal and the formal warning, I think that the child diversion office should do an assessment. Just don't notify. You see, it would make good sense. In other words, and that is where Senator Sharon Golden Campbell has that problem. You have these two sections, 22, 23, that are there. And the best you can say about it is that the police officers of this exercise their discretion not to charge, but the most they've done is to just refer to the child diversion office. My view is that apart from referring it, the child diversion office should do an assessment to see if a program could assist the child or whether it is not necessary. In other words, just to notify the child diversion office makes the two sections almost as we have been struggling with these two sections. And I think, you see, somewhere we should put where it's not only a notification, but it should be a referral for you to decide whether, in fact, an assessment can be done to see if the child could be, if it's a question of just continuous disorderly, then you refer to CPFSA. If you think little mentoring for a couple of weeks or a month would help, then fine. But the way the two sections are is just, just there to say notify the child diversion office. When the child, in the assessment of the police officer, has committed and has accepted that a child diversion offense has been, and I agree with what the police is doing. They're not going to charge a child. But I think somehow, for it to make sense, it should be a referral to the child diversion office for the child diversion office to see if anything more should be done. What do you think, Ms. Clark?
The referral or the document that we use now, the police referral book, allows for the scorecard as indicated before. So the police, though they would be, if it's an informal warning, then we know that that is just oral. But let's say for the formal warning, they have a list of things to consider in terms of how serious is this? Is it something that requires, and they have a score sheet as well to indicate, you know, if it's 6 to 9 points, it's an informal warning. 10 to 12, it's a formal warning. 13 to 19, a caution, and 20 and over, they must be charged. So it depends on the severity of the issue, because, for example, you don't want an informal warning to be sent for maybe loitering or something along those lines, for diversion, when all this child needed was just the police to say, hey, we see you in the evenings, you know, you need to go home after school, versus a child who is now stealing or is suspected of stealing, and the police is saying, okay, we need child diversion to intervene.
No, but
in
the
these
point
matters.
I'm making, though, Ms. Clark, is that the police can do that, and they should do that on a regular basis, just for the purpose of good order in the community. But why then refer to the child diversion office?
So those two, in the act, we should be notified. So the referral really comes in at the caution stage.
Right, but
Chairman,
no.
can I just following on, and I appreciate the line of questioning that you're
Yeah, go ahead.
engaged
Go
in.
ahead, Senator.
But you know, at the beginning of our work in this committee, I recall the Minister of Education being very careful with us in or urging us to be very careful in our distinction between the roles of the child diversion office and the framework there and the work of the CPFSA. And perhaps part of why I'm grappling with this matter, and I come back to it again, is because save and accept in the circumstances of dealing with a child who is in conflict with the law, which has a legal definition, and that legal definition does not include if the child accepts responsibility in the circumstances of a formal or informal warning. It says specifically that children in conflict with the law are those who are charged, arrested, detained. So the Child Diversion Office does not have any authority to do anything with a notification, because under the law, that is not a child in conflict with the law, not on the basis of a warning. It may be that in this circumstance, what we want this to say is that the police have notified the CPFSA, who I believe would have the mandate to be able to engage with this child to see what the situation is surrounding the child. But again, when that notification comes to the child diversion under the existing provision, the Child Diversion Office cannot do anything with it. There is no engagement with the child to say, well, you must do this or you must do that, because they have no lawful authority to do so. That child doesn't fall under their legal framework yet. And that is why I've advocated for this system of warning to be left to the police under the Jamaica Constabulary Force Act, which, because it is a normal part of their policing tools and their community policing tools. And I think we have stepped too far into their domain by putting these provisions in place, which is not to say that I am seeking to water down our concerns about the best interest of the child. But there's one last point I'm going to ask the committee to consider. when we put these provisions in place in respect of police officers, and we say, once you have decided in the case of an informal warning to give one, this is how you must do it. And we say in respect of a formal warning under 2024 that when you give a formal warning, this is how you must do it. Take the child down to the police station, do this, do that. If the police does it any differently or does not do one of the steps, what is the implication for that officer? Does his failure to follow this statutory code then render him a police who has breached his professional duties? And I ask that question because in circumstances with the children, when the police are engaged in executing informal or formal warnings, it is a loose sort of situation, and the police are making determinations and exercising their discretion. And the formalization of how they do that type of community policing, I think, is more problematic than it is helpful to the intent of this act, which is to divert children in conflict with the law. Respectfully submitted, sir.
Right. The only thing I would say is that both sections actually acknowledge that a child diversion offense has occurred. So that the child is in fact...
But that's not lawful.
No, but what I'm really saying, I think we're...
You can't acknowledge that without a court opining on it, without being charged.
No, with due respect. Not everything goes to court because the police, and this is where in all of these cases, the constable can refer the matter to the child diversion office. In essence, remember, matters being referred to the child diversion office can either come from the police or the court. We're going to now
Yes, sir, but after he's charged, after he's detained or arrested.
Right. But I think, and this is where section 22 and 23 come into play, that a child diversion offense has occurred for which the police can charge, but has decided not to charge, but is given an informal or formal warning. My concern is merely notifying the child diversion office ought not to be the end of the matter. The child diversion office should do an assessment to see whether or not the child should be put on the program or to be referred to the CPFSA, or, but just to notify the child diversion office, as both sections say, I don't think that's enough. So what I would really like is...
Very dangerous territory, Chairman.
Sorry?
We are in dangerous territory because we are talking about doing this on the basis of the child accepting responsibility. And the fact that the child has accepted responsibility to the constable, which, by the way, there's a section about the acceptance of responsibility, if I recall. Can somebody just point me to it?
No,
really
well,
quickly?
remember in section 9, when it goes to the court says once a child accepts responsibility, it's a guilty plea. Right. So the position we're saying is that in both section 22 and 23, accepting responsibility means that the child could be put on the child diversion program. So
Is that what it means, Chairman? Because I have great concerns about my child and the police engage in a discussion over something my child has done. My child accepts responsibility, and so the police decides that, okay, it's going to exercise the discretion to issue a warning in this circumstance. What does that acceptance of responsibility mean? And does that acceptance of responsibility in that circumstance have constitutional implications?
No, but what...
If my child saying I'm guilty.
No, but you have a situation in which the child has acknowledged that he or she has committed a child diversion offense. The police has a discretion to charge, issue formal or informal warning, or to caution. My view is that if they charge, it should be referred to the court or to the DPP, as the case may be. But if they decide not to charge, they know that the child may need some some, rehabilitation, and that is where I'm saying once it has occurred, it should be referred to the Child Diversion Office for the Child Diversion Office to make an assessment. What do you think, Ms. Clark? No, but what I would really want to add, I don't like the idea of just notifying the Child Diversion Office. I think it should be referred to the Child Diversion Office. Instead of notifying, it should say that the matter is referred to the Child Diversion Office for the Child Diversion Office to make a decision.
But the Child Diversion Office can't make a decision if the child is not in conflict with the law.
But he
And under the
is.
warning,
He
he's
has
not in
accept-
conflict with the law if he has not been charged or detained or arrested.
No, but with due respect,
Not in conflict
no,
with
with
the
due,
law, that's what the Act
no,
says.
no, but with due respect, Senator Sharon Golden Campbell, the child acknowledged that they've committed a child diversion offense.
And that is even more problematic, sir, because if you're now going to take me into a diversion program like that, you haven't charged me, you haven't detained me, you haven't arrested me. If that is how we're going to do it, then what are we saying is the import of the child accepting responsibility to the police officer? What's the protocols for that? Is the police required without charge or detention or arrest to say to the young man, boy, you have the right to remain silent. You have the right to representation if you're going to accept responsibility like that. We are getting into areas that are concerning to me because we have some strict constitutional protections that are implicated here.
No, but with due respect, Senator Sharon Golden Campbell, that you and I may say the best thing for the police to do is to send the child to CPFSA. And the CPFSA.
I think that's the only thing they can do.
Right. But it's the same thing you're saying, because the child has committed and accept that they've committed a child diversion, we're not going to charge the child. We're going to get to see if the Child Diversion Office can assist the child. And that is why I'm going beyond mere notification. It should be referral to the Child Diversion Office. And that is something we have considered. I felt that that was a gray area where when the police see that the child has committed a child diversion offense, I refer to it as delinquent behavior. Section 22 and 23 allows the child to go on the program without being charged. Okay, I don't see a problem with the two sections, by the way. All right?
Yeah. Chairman, I would like it on record that I am maintaining that the Child Diversion Office does not have lawful authority to deal with the child under the warning system.
All right, so I'm going to ask Ms. Masada to look at both section 22 and 23 and give us an opinion whether or not it breaches, if the child goes on the child diversion program under these two offenses, whether it has any privacy right or it breached the Constitution. Okay, Ms. Masada? All right, now, so for both, we look back at 22 and 23 when we hear from the Attorney General's chambers. So we move to 24. Go ahead.
So Section 24 of the Child Diversion Act reads, the constable shall provide to the child's parents or guardian a copy of the formal warning issued under Section 23, and the parent or guardian shall acknowledge receipt of the copy of the formal warning in writing. So Section 24 speaks to copy of formal warning to say that the parent or guardian of the child is to be given a copy of that formal warning, and the parent or guardian should receive the copy in writing.
The Ministry of Education, Skills, Youth and Information, they recommend that the prescribed form used to issue the formal warning facilitates a section which allows the parent or guardian of the child to acknowledge receipt in writing where this is not provided, and standardization of the process and effective record-keeping principles.
But I don't understand. I mean, why would you need something like that?
The form has it.
There's a form that you just acknowledge receipt. So I don't see any need for expanding it further. All right? Sorry, Ms. Clark. You do that now.
I was just confirming that on the current referral form, there's a section for the parent to sign as well,
Right, acknowledging receipt.
confirming that they have received the referral.
Okay, so that is superfluous. Section 25.
Speaks to police caution under the first schedule. So section 25.1 reads, subject to subsection 2, if a diversion offense specified in the first schedule, suspected to have been committed by a child, is in the opinion of the constable, having regard to the circumstances of the case, requires a more serious response, the constable shall issue a police caution to the child, and the child may be referred to a child diversion program. Subsection 2, a police caution under subsection 1 shall not be issued to a child unless the constable is satisfied that a. The child, 1, accepts responsibility for committing the diversion offense referred to in subsection 1, and the admission was made without being unduly influenced by another person. 2, displays the need for possible psychosocial care or support. 3, is not the subject of a report under Section 6 of the Child Care and Protection Act. 4, has previously been issued a formal warning. And 5, has previously been issued not more than 2 police cautions in respect of a child diversion offense. And B, there is a prima facie case in respect of the commission by the child of the diversion offense referred to in paragraph A1, subsection 3, where a constable issues a police caution, the child and A, the child's parent or guardian, B, the child's attorney at law, or C, a justice of the peace shall attend at the police station within 48 hours after the commission of the diversion offense, and if none of the persons referred to in paragraph A, B, or C attend within that time, the constable may request the attendance of the children's advocate or a member of the child diversion committee of the parish. Subsection 4, the constable shall not give a police caution without the written authorization of the officer or sub-officer of the police in charge of the police station. And finally, subsection 5, a police caution shall be issued by a constable in the prescribed form and manner.
Could you read section 26 too? Because it wraps up with 22, 23, 24, and 25.
So section 26 reads, that's the effect of the constable's warning or police caution. Where a constable has warned or issued a police caution to a child and that child is referred to a child diversion program, A, the child shall not be charged with the commission of a diversion offense in relation to the facts and circumstances which formed the basis for the warning or police caution, and B, no further proceedings shall be taken for the diversion offense in relation to which the child was warned or the caution was issued.
So you see, we have been arguing 22, 23 about the effect of the warning, informal warning, and also the caution. So it seemed to me that what the Act is providing is that once a child diversion offense has been committed, then the police doesn't have to charge. The police can either informally warn, formally warn, or caution, and there are different degrees. So, Ms. Masado, could you also include section 25 and 26? Because I think Senator Golden Campbell is of the view that it could be a breach, you know, when you're putting a person, a program, without charging. And it seemed to me that the section is, you know, these 3 sections that enumerate is giving the police and the child diversion office the opportunity to deal with the child without being charged, okay? And so we just want to be sure that it doesn't breach the constitutional right of the child. All right, yes, Ms. Colgert, yes.
And just to say, Minister, that we had pointed out this section at the ministry for the fact that based on section 22 and 23, which suggests that the child is not directly referred to child diversion on the informal or formal warning, but on a reading of 26 where it says where a constable has warned or issued a police caution to a child and that child is referred to the child diversion program, that gives a suggestion that it is possible that on the informal or formal, the police may still refer the child to diversion. So we were asking for 26 to be looked at in the context of 22 and 23.
Sure, that's the point.
See, yes.
So we asked Ms. Masada to make sure that we're not breaching the rights of the child. And Ms. Graham, could you look at 26? What was the recommendation? Sorry, I'm sorry.
Yes, Chairman, can you identify for me what right would be breached in light of the fact that these sections are actually affording a benefit to the child?
Well,
that's the first question, and secondly, I'm still at a loss as to how it is that a constable, in whether informal or formal, leading up to a caution, is notifying the child diversion committee without having the child on a diversion, which is putting the child a pathway to the diversion.
and that's my view. The
No,
second
and
part-
I'm saying,
point
right,
is-
that's the second, but the issue I'm having is that the process in relation to the constable, as it is worded, is giving a build-up in terms of the nature of the offense, the type of discretion being utilized. Right. And a lot of times these constables are in the actual communities, and when it comes to the formal warning, he can't do so without a senior officer doing so. So the legislation is so well drafted. I'm just kind of confused because we are making amendments.
No, to be fair, we must ensure that there are no rights being breached. But you put it
No,
well.
I'm just asking, in light of that, I'm just saying we're just
but,
blank because
but you put it well. The child could have been charged.
Yes, could have. It's a benefit.
Right. So not being charged is a benefit.
It's a benefit,
Right.
and then we're talking about breaching of rights. When we talk about the breaching of rights,
Yes.
it is if it is demonstrably justifiable and the test
Quite.
is less restrictive measures.
Right.
I can't think of a section that is demonstrating less restrictive measures when
Right.
it is giving a
But
child a
we
benefit.
still will get an opinion from the Attorney General's
Very
chambers.
well.
Okay. Could you read
Mr. Chairman,
Yes,
Mr. Chairman, can I just clarify something because I'm not quite sure that what you're referring to the Attorney General is really the question that I asked. My concerns about the constitutional implications were surrounding the requirement that the child at the time of being warned, whether formally or informally, could only be so warned if they accepted responsibility. And I asked the question, what does that mean? What does it mean for the child to accept responsibility in such a circumstance where they are not represented by a counsel, they may not even be represented by a parent or guardian, and then they're going to be informally or formally warned? I'm concerned about that. That was the nature of, that was what grounded my constitutional concerns. Secondly, the issue of the authority of the Child Diversion Office to take any account of the warnings of a child in circumstances where that child is not yet defined as a child in conflict with the law. Those, sir, are my concerns that I would wish the Attorney General to opine on.
All right. Well, please note that, Ms. Masada, but in particular in Section 23, subsection 1, does not warrant criminal proceeding, the constable may issue a formal warning to the child at the police station in the presence of the child's parent or guardian. So both that and 25, they all said it must be in the presence of the child. In other words, the child cannot accept responsibility without the parents, being, or someone in authority. So if we need to, right, so please check on it. I think a child being vulnerable cannot just accept responsibility without, someone being present. Yes,
So that's not what the language says, you know.
So I kind of wanted to find out, accepting the responsibility, whether formally or informally, the parent must be there. Is that correct?
That's my understanding.
Actually,
I know there is also no duty to accept informally, right?
so just to be clear, so the informal warning says that the child accepts responsibility, but thereafter the police notifies the parent or guardian, right? And then right. So that is what it says.
All right.
So it doesn't necessarily say that the parent has to be present at the time that the child accepts, but acceptance does not mean guilt necessarily. But at the caution stage, which is more serious, where the police is looking to possibly referring the child to child diversion, it then says that in the presence of a parent or guardian, attorney at law, if those are not present, then somebody from the children's advocate.
Yes, Member Buchanan.
That's the aspect that,
Right.
before the court, we took issue with the interpretation of acceptance of responsibility, meaning a guilty plea. The acceptance of responsibility
Doesn't mean
here
guilty
is not
plea.
guilt or innocence.
It is, but the only thing my concern to, and please, Ms. Cole-Jarrett and the team I would like to see whether the informal, formal, or caution, that is not just a notification. It should be a referral, all right? I mean, just putting it as a notification, in my view, is not enough. So let's look and see how that would work, all right? We move on.
Chairman, a moment, please.
Yes.
In section 23, where you read the constable may issue a formal warning to the child at the police station in the presence of the child's parent or guardian. That chapeau is talking about the issuing of the formal warning. It's conditioned on whether or not the child accepts responsibility and has previously not been issued a formal warning or charged. But the acceptance of responsibility, in my reading of this provision, does not have to be in front of the parent. It is a warning that must be in front of the parent. So with respect, this is concerning to me too.
Well, yes, Ms. Masada.
Thank you, Chair. I was just looking higher up in section 2, I believe, subsection 4, where it says what an acceptance of responsibility by a
What
child
section is this?
This is section 2, subsection 4.
Section 2, subsection 4.
Yes.
1 second, let's...
The general provisions, higher
Yes,
up.
that's section 2, subsection 4. Let me...
Yes, I can read it.
Yes, go ahead.
Yeah, it answers it. It
Says
answers
an
it, yeah.
acceptance of responsibility by a child for a diversion offense is not an acceptance for the purposes of this act unless it takes place in the presence of, and it's listed there, A, the parent or guardian of the child, B, an adult other than a constable who is present with the consent of 1, the parent or guardian of the child, or if the child has attained the age of 14 years, the consent of the child, or an attorney at law acting for or on behalf of the child.
Right. So, Senator Sharon Golden, I hope that clarifies the point.
It clarifies the point, and I appreciate that reference. That's the one I was looking for earlier. But it then still gives me the concern, Minister, how does this work in the case of an informal warning? If you catch a child on the street and the parent isn't there, what then has to happen? I don't understand how that works.
We try to clarify that, okay? Because the informal warning is just behave yourself. That's how I see it. In other words, the informal warning really is, did you throw that stone? Yes. Stop, could you please behave yourself? So that's my view. So I don't know if I'll leave it to Ms. Masada to help us out at the next session. Section 27. Let's go. Okay, 26. No, but we dealt with it. Oh, no, give us the,
We didn't read the recommendation, but we did read the provisions.
Right.
the Ministry of Justice and Constitutional Affairs, it is proposed that the act make explicitly clear for an avoidance of doubt when a constable may refer a child for participation in a child diversion program.
All right, so,
Yeah,
right, that's the point. Let's,
Ministry of Education, Skills, Youth and Information, we recommend the removal of reference to warning by a constable in section 26 on the premise that a child should only be eligible for referral to a child diversion program by a constable after being cautioned in accordance with section 28 of the Act.
all right, well, when we get to section 28, we see if any adjustment should be made. But, Ms. Eaton, you can see how a little clarification needs to be dealt with, okay? To make it abundantly clear.
Chair, yes, but I just wish to remind you, Chair, that that is contingent on me being very clear about what the recommendation is being made to the in terms of the text.
All right.
So, for example, the discussion that was just had in terms of the questions of acceptance of responsibility, that's actually following on an earlier discussion. I mean, I know that that was a matter that was looked at earlier by the committee. And the question was to what extent it should be retained throughout the instrument. And of course, now the discussion focuses on the informal warning and the whole issue of whether or not the concept of acceptance of responsibility is appropriate in that provision. So in order for me to draft, I do need clear
Could you,
directions.
when we meet at the final session, hopefully 2 weeks' time, you, Ms. Goldjarrett, have a discussion with Ms. Mesado and Ms. Eaton as to some of the areas that need to be tweaked to make them clear, all right? Some of what the discussion we've had, all right? So that we have a better idea of what we really want in the bill to be recommended to Parliament, okay?
Chairman, can I also add to that very quickly? In those circumstances, the formal and informal warnings, I also not quite sure why we require the youngster to accept responsibility for the constable to warn, whether formally or informally.
Okay.
It doesn't seem to me to need to be there.
Could we check on that and see if that is needed? Yes. All right, could we check? Ms. Mesada, you have heard the concerns. All right, no, 27, we move to 27. Yeah, yes, Ms. Mesada.
No, I wasn't clear on the last point. Was that directed at me?
Yes, what was indicated by Senator Sharon Golden Campbell is to give the informal or formal warning. Why should the child have to accept responsibility? So, as far as she's concerned, I mean, what the senator is imputing, you don't have to get the child to accept responsibility. If the constable suspect or believe that the child has committed a diversion offense, they could just warn or, you know, informally or formally. So why
Isn't that what happens in practice, Chairman? When the police warns, they don't ask you to admit that you are responsible for what they have.
So the question is whether, yes, whether accepting responsibility is necessary. So we look at that, all right? Sorry, Ms. Wright.
Thank you, Minister. Looking back at the original policy, in relation to specifically formal warnings, this is what was said. The formal warnings encourage young people to think through the consequences of their actions, including the impact they have on their victims and communities, with the objective of diverting them from the criminal justice system and deterring them from committing further offenses. The warning system also aims to ensure that young persons, who are at risk of going on to commit serious or serial offenses or who have other supervening welfare concerns are identified and dealt with effectively at an early stage. It encourages the young person to think about the impact of the offense on him or herself, the victim, the community, and on his, her, parents, guardian, and other family members. So that was the context within which the original policy was formulated for formal warnings.
Okay. So I think the idea is to start a preventative approach to behavior. Yeah. Speak in the mic.
Let me just say, for formal warning, I agree for the child to accept responsibility. For informal, where you just, the child's misbehaving, you see the person out and the police is going to tell you go home, then I don't think it is necessary. However, this is a child diversion act that could land him in court, and so I think the child should accept responsibility. I think it should.
So
we will become a wayward society, and I think it is important that we make sure that the child accepts responsibility
and
for something like that.
And there's no detriment.
And there's no detriment to it.
Yes. All right, Ms. Besada, just give us a note on that sometime. 27. Go ahead.
Sorry, Minister. Isn't that more a matter of policy than a legal issue?
You can determine, when you send your recommendation, you let us know, okay?
Okay, would you like to put in writing all the things required of us then to make sure that I'm answering correctly what the committee is saying?
All right, Ms. Graham, draft something for us to send to the Attorney General's chambers, as discussed here, okay? Yes, go ahead, no.
So we're on to Section 27 of the Act. So Section 27 deals with duty to inform victim. Section 27(1) reads, where there is an identified victim of a child diversion offense, the constable shall A, inform the victim that a formal warning or police caution, as the case may be, is to be given to the child. B, explain the nature and status of the formal warning or police caution to the victim. And C, offer to communicate to the child warned or to whom a police caution was issued, or be warned or issued a police caution, the statements of the victim explaining the impact on the victim of the commission of the offense, and subsection 2, where the victim is a child, all communication with the child for the purposes of subsection 1 shall be made by the constable in the presence of the parent or guardian, and the constable shall interview the child to assess impact of the offense on the child.
I think that makes sense, okay? So it may well be we include the guidance counselor or a counselor, you know, who can better understand what is happening, okay? So make a note of that, please. Yes, no.
Section 27 comments, Ministry of Justice and Constitutional Affairs. Section 27, subsection 1, consideration should be given to qualifying the provision to state that, or on the victim's behalf, as the case may be, in accordance with the circumstances as outlined in Section 32 of the Act. And the Office of the Children's Advocate recommendation, incorporate in Section 27, subsection 2, a requirement that where a constable is conducting the interview of a child victim to assess the impact of the offense on him or her, it is done in the presence of a counselor who has the experience working with children and not just in the presence of a parent or guardian.
And we accept that, those proposals, okay? Section 28. Sure.
I just wish to point out to the committee that 27 really clarifies what we were
discussing earlier.
We're going through loops and corners about, and the importance of preserving how the informal, the formal warning and the cautions operate. Otherwise, it's going to make most of the other sections redundant if it is removed or significantly edited.
Okay, 28.
Section 28 speaks to child diversion referral by constable. 28(1), where a constable issues a police caution, the child shall be eligible for referral by the constable to a child diversion committee for admission into a child diversion program in the parish in which the child resides, subsection 2, notwithstanding subsection 1, a constable shall not refer an eligible child to a child diversion program for admission to a child diversion program unless the victim of the diversion offense, if identified, consents in writing in accordance with section 32 of the child's referral. 3. If the victim of the diversion offense consents for the purposes of subsection 2, the constable shall cause the consent to be recorded. Subsection 4, where the victim referred to in subsection 2 does not consent, the constable shall not refer the child to the child diversion committee for participation in a child diversion program, and the constable may charge the child for the commission of the child diversion offense.
I think you need to read everything. What are the recommendations?
Recommendations from the Ministry of Education, Skills, Youth and Information. We recommend the removal of the requirement of the consent of a victim in section 28 on the premise that a caution should flow from the investigations being undertaken by a constable, and as such, the constable in his or her professional capacity should determine whether a caution should be issued. This recommendation would also affect other provisions under the section which makes reference to the issue of consent of a victim. Then there's also a recommendation from the Jamaica Constabulary Force. The following recommendations are for section 28. Section 28 appears to limit the admission of a child into the program to situations in which a caution has been issued. This drafting gap undermines the operational intent of the Act and may hinder the program's rehabilitative reach.
Yeah, they're concerned why you need the consent of the victim. What do you think, Mr. Clark?
Minister and members, there will never be a situation where I agree to omit the voice of the victim. There is no justice unless it is perceived at least to be just. Because if a crime was committed or an offense is committed and I don't have a say in there and I am the one that was hurt, then reprisal is almost inevitable because I'm going to now find a way to get the justice I am seeking if it is not given to me in this way.
Yes, I think that's an appropriate comment. What do you think? Go ahead.
You know, Chairman, this is a slippery slope. Again, I'm always cautioning because there are several scenarios. There are going to be victims that are adults. There are going to be victims that, especially in the Jamaican space, I just need to use one word, land. And children get caught up in generations of fighting, and aunties are victims, and they in order to hurt the sister, the nephew must go down today. Mm-hmm. And if you require the good graces of such a victim, it's not going to come. The child diversion, the purpose of the child diversion is to put the child. No, it's to put the child into a program to curtail habits or actions that we want to get rid of. And if it's going to be hindered by victim consent, we're going to find ourselves in problem where victimless crimes are going to be the only situations where most children benefit from. And I think that when we have restorative justice, mediation, and the other mechanisms, victim support, and then bring mediation to the table, the consent
we don't accept that recommendation. Okay. The consent of the victim should be agreed.
So, but I'm going to say, though, Minister, that we should have more conversation on this because I don't think that the consent of the victim is required. That's my position. And we should probably have that conversation.
The law allows, though, for where the court believes that the victim is being unreasonable for the matter to be sent to child diversion, and that.
But the problem with the thing about the child diversion is we want to divert as soon as possible. We want this, especially in this section, we're talking about the constable already saying that this is a caution, this is a warning. It don't give rise to needing even consent. So it's hindering the work of the police who is making a particular assessment. And if we have to go to court, it's kind of making it redundant why we want to divert them away from the court in the first place. So I'm saying we have restorative justice, we have mediation, we have victim services, and we have other mechanisms that we can have victim involvement to empower them. The mediation would be the compensation aspect of it through the court, as well as the restorative justice will bring the family dynamics into it. But you have to treat victim support and child diversion as two separate programs that's running, which would include the other ones where we bring victim and offender together.
But I don't think we should disturb this present section. Leave it so that if it's unreasonably withheld, then we have to go to court. If it's unreasonably withheld. Okay. Go ahead.
Chairman?
Yes.
Can I just say, I agree with Member Buchanan, and I adopt all of what he just said. I just want to point out that no less than the Ministry of Education, Skills, Youth and Information have recommended to us the removal of the requirement of consent of the victim. And I just wonder, when we have our central government bodies offering us a recommendation, not to say that we take everything carte blanche, but it certainly seems to carry some weight for me, because they administer another aspect of the children's support systems. So I too agree that the victim consent matter makes this unreasonably bureaucratic and defeats some of the purposes of the Act.
We touch on it. Can we delay that the final decision when we get to Section 32? Because Section 32 deals with consent of the victim. Let me ask Ms. Clark, have you ever had, do you have many situations in which the victim object?
Not that I'm aware of, but as indicated before, you know, the court has that opportunity to do it. But while we speak about restorative justice and victim services and child diversion separately, they're all interconnected. So we don't want to put ourselves at risk for situations to escalate, because we're saying just from the get-go, we're not considering your view as the victim.
Well, you see, the victim's views, in my view, really should be given consideration. Just ignore the victim creates a lot of problems in terms of moving forward. But I agree, the victim's consent, if it is unreasonably withheld, then we get the court to agree.
Chairman, can I make one other point on this? And I know we're going to look at 32, but you know, in the situation where the victims, in a situation where a prosecutor decides not to go forward with a matter, sometimes it has nothing to do with victim consent or not speaking to victims. Sometimes the prosecutor decides that there's just not sufficient evidence to have a successful prosecution. It seems to me that if the state is saying that as a matter of policy, this is how we're going to treat with children in conflict with the law, that policy should not be based on whether in an individual matter the victim consents, but rather the state should provide support for the victim on a case-by-case basis in the specific circumstances. And those are the things that I think Member Buchanan was raising, that there are other ways in which the victim can participate and the victim can indicate, you know, how they feel and be heard, etc., etc. And those things, I would imagine, are things that are also taken into account in terms of the type of child diversion program that's established for the particular child. So I hear it repeated that we will go to court, but that's exactly what this whole act is about. It's about trying to avoid going to court.
CPFSA, what's you made this recommendation, I think, or coming from your, you want to support it or?
We're in agreement with what is stated here regarding waiting on the victim's consent is defeating the purpose of the Diversion Act. We're trying to divert children away from the criminal justice system. If we put that in the victim's hands, it may delay the rehabilitation of that offender child that we're trying to save. So we can't depend on the victim. As I think that there are other means that we can get the victim to participate in the process. When you have restorative justice, they are needed there to agree. And also other means, what? And mediation as well. But to say a victim is supposed to be given the responsibility as to whether an offender child is to be in the program, it's going to defeat the purpose of why we're doing what we're doing.
I think we need to give this matter some further consideration. I think we hold it until we get to, let us see what 32 is saying. Go ahead with 29 and 30.
Section 29 speaks to record of warnings and police cautions to be kept. 29.1, a constable who gives a formal warning, a police caution, or makes a referral to...
Okay, there are not much complaints on 29. So we go to...
Do we have any comments?
No. 30 and 30 is basically just a recommendation that we consider. Both 30 and 31 are just some recommendation. Ministry of Justice, you can put it to, we'll put it forward, okay?
Okay.
So we accept those recommendations. Then 31 is basically, I don't know if there's much.
30, Jamaica Constabulary Force had a recommendation in relation to the notice to the child, yes.
So if I can read section 30 quickly. Notice to Child Diversion Committee. Yes.
Yeah.
I know we're just glancing over this record and the warning and the procedures in terms of the record keeping. We made mention of the no keeping of record in the informal. And there, if we're talking about the constitutional and the privacy issues in relation to the child, these are warnings and cautions whether or not an officer is to be keeping records like this and it being held at a police station without the proper checks and balances. And there's a particular section that says after 5 years, it is expunged. This is language that I think it demands a little bit more consideration because of this is a profile, the very profile we're saying we don't want to be held somewhere for children in police stations. And so we just passing it is a little bit problematic. The particular section, it says 29.3. Subject to subsection 4, a sergeant or an officer above the rank of sergeant shall, after a period of 5 years from the date on which a formal warning was given, cause the entry in the register recording that formal warning to be expunged from the register in accordance with such procedures as may be prescribed. It's problematic. Children, how long do children in conflict with the law hold these records?
Member Buchanan, once you give a formal warning, it's going to be recorded. You can't say it should not be recorded.
I understand that. I'm saying, shouldn't we be thinking about how to secure or how to protect the privacy of children?
Yes, but I mean, I'm saying that obviously, surely if the charge is recorded, you give a lesser approach, a formal warning, to say it should not be recorded. I'm not too sure I'd agree with you because a formal warning has been given and I can.
But the formal warning is not a charge or a caution, and yes. I think that's where I'm going to have some discomfort because it is not a charge.
Admittedly, but still, bear in mind now, they're going to be referring in these cases or notifying the child diversion officer, and maybe it should be really a referral rather than notification. They have to do some record.
I'm not taking issue with the record. I'm taking issue with the process and procedure and the lack of direction as to how those records are to be kept and what it should be used for.
No, but its record are kept. I am not too sure how it, but after 5 years, as you say, it is expunged and should not be used after 5 years.
And where it's not expunged, what is the
No, but then
punishment, the crime?
the constable would have disobeyed the law because the law says after 5 years it must be expunged. So that, let us say a 16-year-old and 5 years they are 21, it may well be, that they commit an offense at 21 and they say, they engage in something. So
No, but that's the problem. This is not it's not even a charge. It's a warning. It didn't result in charge.
And admittedly, Member Buchanan, but the truth of the matter is, once the police engage in action like that, a formal or caution, they're going to record it. We can't tell them not to. Okay?
Very well.
I think we want to do 32. Go ahead with it. Go through 31 and quickly to 32.
So Section 31 of the Act speaks to calculation of number of police cautions. A constable in calculating how many police cautions have been given to a child shall include any police caution given within the preceding 3 years by A, another constable at the police station, and B, a constable at another police station in the parish or in another parish.
You see, then that section, if they should at least know that it was done.
But we don't have a record.
I'm not taking issue with the recording. I'm saying that these things are here and there are no checks and balances in terms of the method and the process.
But you see, Ms. Clark, this is where, and I think you're correct, this is once these warnings or cautions are given, that is where I believe there should be, from the Child Diversion Office, some response that you haven't notified us. We assess the situation. We think the child was mentored for 1 month and sent back. You understand, Member Buchanan? In other words, once it's done and it's referred or notified, that's where I'm saying the Child Diversion Office should be able to have a record too that they responded to the police, that the matter was dealt with. Yes,
So typically all police stations should have a separate station diary specifically for, in particular for child diversion by itself. So what will happen, and we provide those books, we provide the diaries as well. So for matters pertaining to child diversion, they would only be logged in that diary. There was another issue that
all right.
I've lost my train of thought.
Chairman, but I wish you didn't turn off your mic, Mr. Clark, because I hear what you're saying, but is that done in practice? Because half the time when a judge says, let me see the station diary, everything is just in the station diary, and is there training for every single new cohort of police officers to know that they're not to be writing in the general book when it comes to a particular thing? So I know about ideal, but I'm concerned about the practice, especially because that direction is not recorded here in the legislation. So I'm not objecting to record keeping. I'm saying the process is not reflected in the legislation. That's it. And we just went past section 29.
So
all right, see Ms. Eaton.
Go ahead, Mr.
So just to confirm, it happens in a lot of stations. I cannot say it happens in all police stations. What we have been, and we have been sensitizing, that is done on an ongoing basis. What we've been moving to do, though, is through communication with JCF to be included in their training curriculum. So all the new police officers do understand that there is a need for child diversion, and this is the path that you will take, and a better understanding of documentation, what is expected, and the engagement that we provide with them.
All right, we need to just, we're going to finish up on, sorry. Go ahead then.
Chair, thank you. And I just wanted to remind the members of the committee of the earlier intervention by the ministry where it was indicated, every time you see the word prescribed, that is a subject matter that should ideally have been the subject of regulations under the Act.
Okay.
But the regulations have not yet been, they're not
All
yet
right,
in place.
thanks. Make a note of that.
Minister,
Yes.
I just wanted to know if, for Member Buchanan, Section 39, the general obligations, the secrecy, if that section would address any of your concerns. And I notice it goes further in subsection 3 to say nothing in this section prevents disclosure to any person which is permitted or required by law or pursuant to an order of a court. So I don't know if that section would help.
It should satisfy your position. All right, we want to finish up because we're losing the quorum. So we're just going to do 32, and could you just go to 32? It seemed to me 32 is almost an overriding section throughout because it requires the consent of the victim almost in everything. Go ahead,
Section 32 speaks to consent of victims. Section 32(1) reads, subject to subsections 2 and 3, where a victim consents to A, the issue of a formal warning or a police caution, or B, the referral of a child to a child diversion program, that consent shall be in writing, signed, witnessed, and recorded in the prescribed form or manner, if any. Subsection 2, where there is more than one victim, the consent of each victim is required. Subsection 3, in any case where a victim is a person under the age of 14 years, consent for the purposes of this part may be given on the victim's behalf by 1, the victim's parent or guardian, or 2, the children's advocate if A, the parent or guardian cannot be located, or B, the court or the constable, as the case may be, is satisfied that the parent or guardian is or appears incapable of giving consent for the purposes of this act by reason of any physical, intellectual, or mental impairment. B, a person who has attained the age of 14 years and who the court is...
All right, but we can stop. It's clear throughout the act, the consent of the victim seems to be a primary focus. So I don't know if we can really at any place remove the consent of the victim. The whole act itself would be completely overturned.
Minister, a lot of the provisions are interconnected.
Yes.
So when we read them in isolation, we may miss certain aspects of how the act is to be read holistically. So.
You see, what we're saying is not in every case, but there are appropriate cases. And, to remove consent generally, it would overturn the whole structure of the act that you want a child to, and most of these children are being treated in their community, and most of their offenses are within the community. So it's always useful to have the victim be a part of the whole arrangement. Yes.
I can only think in relation to sexual autonomy, where that is the height of sensitivity, where consent, victim consent and trauma from a particular victim may be called into question. But I cannot see requiring the consent of a shopkeeper for children climbing over his wall and entering his shop, and how he feels about protecting his business versus correcting bad behavior of a child. So while we are doing this amendment and trying to modernize the legislation, if we're speaking about victim consent generally, there should be no requirement for victim consent. And if there are circumstances that there are persons who feel that victim consent is required, then that should be set out somewhere or particularized. But I'm thinking that it's going to hinder the spirit of child diversion to hold victim consent, to have a victim hold the program hostage.
All right. What we'll do, Ms. Wright, and could you please let us see how this can be treated when we next get here, whether in fact it is absolutely necessary, Section 32 and the other consent, what was in the original provisions. And really and truly, I'm really hoping we can finish up at the next session, because we don't have much more to go in terms of the matrix. And yes,
Mr. Chairman?
yes, yes.
I've been trying to ask a question in relation to the formal warning provision of Section 23. I may have missed it, but where in that provision is the constable required to seek the consent of the victim when he's issuing a formal warning?
In 23,
Yes.
I'm not too sure that's the one that was being referred to. It was in 20, it was in, I don't think the consent was required in 23.
No, I'm not seeing where it is, but Section 32 speaks to the where a victim consents to the issue of a formal warning. And I'm not seeing where in 23 there was any requirement for victim consent to issue a formal warning.
Sorry, go ahead, Miss. Turn on your mic.
I believe there's a general provision that speaks to the need for the victim's consent, so I'm looking for it to refer.
A general provision
right.
for victims' consent. That's.
I'm looking for it, Mr.
You think you're there's somewhere in the act. Consent has always been. If you look at Section 9.2, Section 9.2.
Section 9.2 speaks to referral to the child diversion program.
Also, Section 21.
21.2, Chairman.
20, sorry.
21.
Section 21.2.
Right.
I mean, throughout the bill, and I think that was how the act was put together. The idea is that there should be a general consensus from the victim.
Can I ask then, Chairman?
Mr. Chair, Section 27 also speaks to it, I gather. Section 27.
Yes.
Sorry, my
Yeah, go ahead. So consent of the.
Sorry, go ahead. I was asking the question, Chairman. In the case of in practice, what actually happens when the police are giving these formal warnings? Are the police getting the consent of victims when they issue these formal warnings?
The truth of the matter is that
what system does the child diversion office have to determine whether or not the police get the consent? When they issue the notification to the office, do they have to include in that notification that the victim consent was?
Ms. Clark, do you know what was being asked? When they notify us of a formal warning to a child, do they send us a written thing and say the child, the victim consented, or the offender was accept responsibility? What comes to us when it notifies informal or formal or caution?
So it is one form that is used, and the form has a section that says victim's consent, and it indicates the victim gives consent for a child to participate in the diversion program for an informal warning, formal warning, caution, or referral to diversion program. So it allows, that's what happens now. Everything is on the same form for all of the warnings and the cautions.
Okay.
And so the police fill out that form?
The police along with the victim and the accused.
Yes,
so, okay, so there's a section on the form where the victim has to sign?
Yes, there is.
Could you bring a couple of the forms the next time?
Sure, I can email a soft copy to Mr. Nash.
And
Yes, I
Mr.
will.
Nash can circulate it. Yes, Mr.
It's just to ensure that we make it tidy when we're dealing with the victim consent. Section 27 just puts a duty of the officer to inform the victim and sets out clearly that there is no victim consent. It just informs them whether it was a formal warning or it was a police caution, explains the nature and status of the formal warning or the police caution to the victim, and offer to communicate to the child warned or to whom a police caution was issued the statements of the victim explaining the impact on the victim of the commission of the offense. So there is no consent in relation to the warnings and the caution.
All right.
And that ties into the issue about whether we just, the notification to the Child Diversion Committee, because Section 28 speaks about the child being eligible to participate in the child diversion program. So the act has to be read section by section and as a whole, and this isolation of the sections is making it complicated.
Okay, we don't have that many sections which we have here, and it can be dealt with, I hope, in the morning of another day. We're looking at 2 weeks' time, okay? But what is more important, when we meet again, and we're going to try for the 12th of August, is for a number of the concerns raised by committee members to be addressed. Ms. Wright, you were part of from the beginning.
Yes.
Could you, I would like you to address the committee members that day, how...
In relation to the consent of the
Not only
victim?
consent, but also how, you know, the Section 22, 23, the informal, and if you don't mind discussing it with Ms. Cole-Jarrett and other members, right? So that some of the concerns of the committee can be addressed. You have heard many of the concerns, not only consent, but also whether in fact why accept responsibility and how it works.
Right.
Right? So that, in other words, we want, when the report is drawn up, that we have a consensus and at least some of the concerns can be addressed. Fine. The question of whether the rights of the individual will be breached if they, you know, decide to accept responsibility and so on. Please have a discussion with Ms. Misado and the AG Chambers.
Okay.
And in terms of the other matters, Ms. Clark, you please lead it off with Ms. Graham and Ms. Cole-Jarrett, okay? To address all the other concerns, because that will be the final meeting, hopefully on the 12th. And a lot of it will be dealing with addressing the concerns of the committee members, all right? All right. So I want to thank everyone. I think we're going to stop here because we have lost a few of our members and we just will write them. And we want a recommittal. Sorry? All right, no problem. Member Tova Hamilton sent in the apology late that she wouldn't be able to make it. But we're going to urge Mr. Nash to just write a committee members to ask if 2 weeks' time, the 12th, at 10 o'clock, we can meet to wrap up. And around by then, it gives you enough time to do all the minutes, which can be then sent to committee members, because we want Mr. Nash and Ms. Ashley, that after that, you can start drafting the report, so we can then just submit it early in September, debate it in September, and then we can do the adjustments as the case may be, all right? Because once we file that report, to be frank with you, we have other committees that we need to start again. So thanks, everybody. Thanks, Senator Golden Campbell, Minister Williams, thanks for joining us virtually. Thanks to the members who are here. Thanks to the teams from everywhere, AG Chambers, CPFSA, Ministry of Justice and Constitutional Reform, from Parliament. Thanks again for sharing the day. And we had a good day. Thanks, everyone.
Thank you, Chairman.
Thank you very much, sir.
Okay, good now.